5 seconds to go. Start. In state of MP and others, etc., etc., versus Neelam Singh and others, etc., etc., 2009 9 SCC 999, the court observed that it is well settled that power of the High Court to issue an appropriate writ under Article 226 of the Constitution is discretionary. It has been further stated therein that if there is inordinate delay on the part of the petitioner in filing a petition and such delay is not satisfactorily explained, the High Court may decline to intervene and grant relief in the exercise of its writ jurisdiction. Emphasis was laid on the principle of delay and laches, stating that resort to the extraordinary remedy under the writ jurisdiction at a belated stage is likely to cause confusion and public inconvenience and bring in injustice. Thus, the doctrine of delay and laches should not be lightly brushed aside. A writ court is required to weigh the explanation offered and the acceptability of the same. The court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the rights of the citizens, but simultaneously it is to keep itself alive to the primary principle that when an aggrieved person without adequate reason approaches the court at his own leisure or pleasure, the court would be under legal obligation to scrutinize whether the lease at a belated stage should be entered or not. Be it noted, delay comes in the way of equity. In certain circumstances, delay and laches may not be fatal, but in most circumstances, inordinate delay would only invite disaster for the litigant who knocks at the doors of the court. Delay reflects inactivity and inaction on the part of a litigant who has forgotten the basic norms. In the case at hand, though there has been 4 years delay in approaching the court, yet the writ court chose not to address the same. It is the duty of the court to scrutinize whether such enormous delay is to be ignored without any justification. That apart, in the present case, such belated approach gains more significance as the respondent employs being absolutely careless to his duty has remained unauthorizedly absent on the pretext of some kind of ill health. We repeat at the cost of repetition that remaining innocuously oblivious to such delays does not foster the cause of justice. Such delay may have impact on others' ripened rights and may unnecessarily drag others into litigation. In our considered opinion, such delays does not deserve any indulgence, and on the said ground alone the writ court should have thrown the petition overboard at the very threshold. Having dealt with the doctrine of delay and laches, we shall presently proceed to deal with the doctrine of proportionality, which has been taken recourse to by the High Court, regard being had to the obtaining factual metrics. We think it is appropriate to refer to some of the authorities which have been placed reliance upon by the High Court. Stop.